The remedies question from February of 1997 is either a very difficult problem or a very easy one, depending on how well you know the law. I'm including it because I want to make sure that you are well acquainted with a couple of the legal details. Also, this is another short fact pattern, and you know the shorter ones can be more problematic than some of the longer, more complicated ones. This also is an example of a fact pattern that has a couple of calls of the question that it's possible to answer without even reading the fact pattern. That's how narrow and specific the issues they ask are. So let's have a look at this call of the question. I'll show them to you. 1. How should the trial court rule on the merits of Peter's action? Discuss. Well, here it looks as if we're being called on to analyze a theory of liability, and maybe a prayer for relief. It's likely that this first call of the question will require us to do fairly elaborate work, and also fairly intellectual work, because we're going to have to figure out what the theory is, and the defenses, and maybe the remedies too. 2. If the trial court issues a mandatory injunction requiring Debbie to have the porch removed within 30 days, but Debbie does not comply, what procedural steps should Peter take to make her comply, and what should be the result? Discuss. Well, although it's probably helpful to read the fact pattern, we can craft a fairly thoughtful answer to this part of the question without even reading the fact pattern. What we are being asked about here is how to enforce a non-money judgment. We've got a court issuing an equitable order, and a party disregards that order. Here we're being tested on contempt. The court can use its contempt power to force a non-complying party to obey. And so what Peter will have to do is bring a motion for contempt, and the court will then decide the motion and presumably punish the non-complying party. So call of the question number 2 is one that can be answered without much reference to the fact pattern. At least that's our initial reaction. Now go to call of the question number 3. If the trial court concluded that Debbie willfully disobeyed the injunction and fines her $1,000, but in Debbie's appeal, the appellate court concludes that the injunction should not issue, how should the appellate court rule on whether she should pay the $1,000 fine? Discuss. And here again, we don't need to read the fact pattern to be able to write a succinct, correct answer to this question. And if there is any issue in this fact pattern that you don't know, it's going to be this one. Here we're being tested on a relatively obscure area of law, and you've got to know it in order to be able to write an answer that really is exactly on point. The point is the collateral bar rule. The collateral bar rule indicates that a party must obey a lawful court order or appeal it through reasonable channels. And if a party willfully disobeys a court order without following appropriate procedures, that party is liable for sanctions, even if on appeal the underlying order is overturned. And the reason is the appellate court can handle judicial error, but a trial court is empowered to handle a non-cooperating party. And the lawfulness of the contempt citation will not be overturned by an appeal of the underlying decision made by the court. So that gives us a quick answer to call of the question number 3, and as it turns out, it is a complete answer. We haven't even looked at the fact pattern. Finally, go to call of the question number 4. If Peter had not commenced his action until 1 year after his discovery of the encroachment, and Debbie had moved to dismiss because of the delay, how should the trial court rule? Discuss. Well, here, if there's a statute of limitations on point, we will analyze it. If there is no applicable statute of limitation, presumably it will be longer than a year in any event, then Debbie would have to show some form of actual prejudice caused by the delay. Presumably, this would be a rather difficult burden for her to meet. So question 4 also does not appear to rely a lot on the facts of the pattern. So let's now go look at this very short 3-paragraph fact pattern and see what's really going on here. In paragraph 1, we learn about Debbie and Peter. Both of them have purchased lots from prior owners. They are nice oceanfront vacation houses, and they are on lots 1 and 2. They are adjacent to one another. In paragraph 2, Peter hires a surveyor to lay out the boundaries of lot 2, and he does it after he and Debbie have completed their purchases, or at least after Peter has completed his purchase. In particular, we find that Debbie's 10-foot wide porch extends laterally 7 feet onto Peter's property. The encroachment was made by the original developer 25 years ago. Well, why do you think it is that the examiners chose to tell us how many years elapsed? The answer is to cause us to go through an adverse possession analysis. And it turns out that the first call of the question, in fact, is by far the most complicated call of the question, and it's going to require us to go through a lot of specific factual analysis. But even before we complete this fact pattern, I am hostile to Peter. And the reason is not merely because of my built-in pro-defense bias, but because this guy, Peter, already got the benefit of his bargain. If he was concerned about the boundaries, he should have investigated them before he completed his purchase. So it looks to me as if this guy, Peter, is trying to get more than he bargained for by using real property law and the courts to try to sweeten the deal that he already cut and concluded. So I'm not sympathetic to his encroachment claim, and as we'll see, the analysis supports that hostility. Finally, in the last very short paragraph, Peter commences an action to compel Debbie to remove the porch 6 months after he learns of the encroachment. And then we get the call of the question again. Well, this fact pattern does fit into a pattern that I've commented on before. The shorter fact patterns tend to be harder because we've got to find a home for every last detail. There really isn't a lot of places to hide when we're dealing with so few facts in the pattern. So now please flip the page and take a look at my outline of issues. Here, again, as so often is the case, careful, meticulous organization really is a key to being able to write a solid, sensible, comprehensive answer to this complicated question. So let's take a look at the outline and look at Roman numeral number 1, the merits of Peter's action. Well, fortunately, it turns out that we didn't have to dream up what his theory of liability is. They tell us it is encroachment. And there isn't a whole lot to analyze there. The porch, in fact, does extend beyond the boundary line. So it's clear that at least 25 years ago, this porch was an unreasonable intrusion onto Peter's lot. The defense to the theory of liability is adverse possession. And here again, I break adverse possession down into the bar exam format, the mental, the physical, and the time element. If you're a scholar on adverse possession and you know the more subtle approach, you're welcome to use it. But for bar exam purposes, this simple format is acceptable, and it's even appeared in a couple of example answers that the bar has published. So we know that it's legitimate and not just some shortcut that those of us who work in bar review dreamed up and have tried to foist off on an unsuspecting public. I like this defense. Even though Debbie personally has not occupied this property for a long time, in fact only for a few months it seems, her predecessors in interest and the predecessors in interest to Peter's lot have dealt with this situation for longer than the statutory period, almost for sure. Next, we focus on Peter's remedies, and here again, we're focusing on a comprehensive set of remedies: damages, restitution, and injunctive relief. And here I break down injunctive relief analysis to make sure we consider each element. In the end, I conclude that Peter's action lacks merit. But that doesn't excuse us from proceeding to answer the rest of the question. With regard to our answer to the second call of the question, here I am more or less just following what the fact pattern tells us. We know that the only real way that Debbie can be forced to comply would be with a contempt motion. She's got a valid defense to the contempt action, which is that a good faith appeal is underway. Debbie's mistake here is a procedural one. She should have asked for a stay of enforcement pending appeal. A judge certainly would have been likely to grant that motion, and had the court denied it, it likely would have been one more element that she could have appealed, probably on an expedited basis. but she's liable for sanctions if she merely ignores that order, as we discussed below. Next, we focus on the third call of the question. Again, this is a simple question, and you either know it or you don't. It's the collateral bar rule. And I indicate that Debbie failed to seek a stay. Had she done so, she wouldn't have faced this problem. The bottom line is she's liable to pay the fine because of her own unclean hands. Next, we look at Debbie's motion to dismiss. They don't give us very much to play with here. There is no statute of limitations indicated in the fact pattern. There is no sign of unreasonable prejudice suffered by Debbie as a result of an additional 6-month delay. So I conclude that her motion to dismiss is likely to be denied. Okay, so now we've organized a careful answer to this tricky, difficult, short fact pattern. Now, for a moment, let's review my model answer to this question, and I'll point out a few paragraphs that might be worth a little bit of further review. Notice up front, I'm leading with the facts under encroachment, and you'll see I don't waste a lot of time on the theory of liability. It's more or less a given in this fact pattern. We are told that this porch extends 7 feet over Peter's property, and there's not really anything to analyze. So we focus instead on where the action really is, which is on Debbie's defense. So for a moment, let's take a quick step back. The fundamental approach that I've been advising you about from our very first session together is a simple, straightforward, and intuitively easy approach. I think we need to consider the theory of liability, the defenses to the theory of liability, the prayer for relief, the defenses to the prayer for relief. If you enter this fact pattern with that very simple framework in your mind, it's unlikely you'll do a poor job answering this first call of the question. Where people choked and failed the question, and in some cases failed the bar exam as a whole, was as a result of not having good technical skills. So we focus on Debbie's defense, an adverse possession defense. And here I lead with the facts about how the original developer was responsible for this encroachment 25 years ago. And I indicate facts that are likely to hurt Peter's chances in court. Then I focus on the 3 basic elements of adverse possession: the mental element, the physical element, and the time element. And here again, I am finding a home for the facts, and I am analyzing those facts in the context of adverse possession law. So I would argue that Debbie is allowed to rely on the amount of time that her predecessors in interest and the plaintiff's predecessors in interest occupied their respective lots in order to defeat Peter's claim. So in the end, I hold for the defense, but that doesn't excuse us from considering the remedies analysis. And you'll see I spend more time on remedies than I spend on the theory of liability. First, I focus on damages. Obviously, the plaintiff's preferred remedy in a real estate dispute is equitable relief. But it would be possible to calculate damages in a couple of different ways, either the value of the encroachment or the diminution in value of lot number 2. Next, we can focus on restitution, and here I don't think the facts really support a restitutionary remedy because there's been no benefit conferred. Finally, we focus on a mandatory injunction, and obviously this is the preferred remedy, although I indicate up front that Peter is unlikely to succeed on his theory of liability. But we're considering with our analysis of remedies, and so we quickly focus on the elements. Damages almost always are inadequate in disputes involving real estate ownership. The property right obviously is satisfied here, as it just about always is, and then we move on to feasibility. Again, it's simple. A court easily could make this order, and as we'll answer below, enforce it if we've got a party that's unwilling to cooperate. Next, we focus on balancing the hardships. And this paragraph, I think, may be the most insightful paragraph of analysis that I give in this answer. Have a careful look at it. Basically, what I'm arguing here is that Peter and Debbie both got the benefit of their bargains when they purchased these lots. I'm hostile to Peter's claim because it seems to me it is too late. He should have made this analysis done before escrow closed. and his failure to do so, I think, is going to defeat his claim. Next, I discuss defenses to equity, and here I don't think Debbie has a defense to the injunction other than her defense to the underlying theory of liability. I think that the balance of hardships and fundamental fairness notions favor Debbie. I limit Peter to money damages, if any. Ultimately, I find for the defense in the overall case. Now we move on to consider our answer to the second call of the question. You'll see here, although this part of my answer is substantial, it is not terribly long. I focus on the contempt citation, I explain what it means, and then we move to Debbie's defense that a good faith appeal is underway. And I reach the result that Debbie needs to seek a stay of enforcement, and she'll be subject to sanction if she fails to do so. Next, we look at the appellate court and the fine. Here we're being tested on the collateral bar rule. You either know it or you don't. Now, let's say for a moment that you don't know the phrase collateral bar rule. Well, you didn't really need to mouth those magic words to pass this question, although obviously it would be helpful. But what you did need to do was explain that Debbie's bad faith in refusing a lawful court order is enough that she is liable even though the underlying dispute is resolved in her favor by the appellate court. The real problem for Debbie is that she did not procedurally handle this situation correctly. She just ignored a lawful court order, and she's not going to get away with it. So the bottom line here is Debbie has to pay the fine despite the fact that the injunction was wrongly issued. Finally, we consider Debbie's motion to dismiss. I consider this to be the most insubstantial question presented. I spend the least time on it. But even so, I'm able to come up with a couple of fairly straightforward, on-point arguments. First, I talk about the statute of limitations. It seems unlikely that this claim would be barred, but if it was, then she would succeed in her motion to dismiss. Next, we consider a possible laches defense, but here she would have to show some kind of special prejudice, and I think it's unlikely she'll be able to show that. So I conclude that unless the 1-year delay caused Peter to miss the statutory deadline, his action would be allowed to proceed all the way through the judicial system. And that wraps up a consideration of a complicated, short, fairly difficult fact pattern. And if you didn't know all of the law going in, I don't imagine you're going to forget it now.